Good morning, everyone. Can you hear me, please? We are about to commence the webinar for today. And the event is hosted by the Jury Justice and Rectitude Advocacy Initiative. The theme of the event is the role of the jury system. The theme of the event today is the role of the jury system in restructuring the criminal justice system for efficacy in fighting corruption. Once again, I want to welcome us all to this August event. And we are making progress in bits in our advocacy for the adoption of trial by jury in the criminal justice system. I want to apologize for starting quite behind schedule. One of our moderators has been having some technical issues joining in. So that said, I will want to acknowledge the presence of our honorable chairman for today's event, the executive secretary of the Presidential Advisory Committee Against Corruption, is Professor Sadiq Isarada, is a one-time Deputy Vice Chancellor of the BUK. I also want to appreciate and welcome the representative of our distinguished keynote speaker, the Director General of the Nigerian Institute of Advanced Legal Studies. Is ably represented today. That's Professor Mohammed Ladan Taufik, is ably represented by Dr. Hazard. And also the Honorable Chief Judge Kadunan State is a very amicable Chief Judge. Is represented today by Honorable Justice Darius Kobo. The Attorney General just sent in regards and said that she'll be represented by the new Solicitor General, Mr. Katungu. We are expecting him, but I believe we can start. So not to take much of our time, the chairman of the Jury Justice and Rectitude Advocacy Initiative, Mr. Dave Ajetomobi, will welcome us properly to this August event to give us the welcome address. Thank you very much, sir. Mr. Dave, you have the floor. Yes, and before I forget, I am Esho Mama Ogene, the nodule of the Jury Justice and Rectitude Advocacy Initiative. Yeah, you would, in the course of this advocacy, you'll be seeing quite a lot, and I hope I apologize. We are still trying to reach out to Mr. Dave, but in his absence, we will take the welcome remarks from the chairman of the event, Professor Isarada, the executive secretary of the Presidential Advisory Committee Against Corruption.
Okay.
Thank you, sir.
Thank you very much for this opportunity. Can you hear me? Can you hear me? Shamsuddin, it seems you are the only one hearing me.
Yes, sir. You have the floor, sir.
Okay, thank you very much. Now, before I formally welcome everybody, let me begin by saying that at the Presidential Advisory Committee Against Corruption, any input, any effort, any strategy, any innovation that is brought on board in Nigeria to assist the fight against corruption is welcome. It is in this regard that I feel the committee is delighted and extremely happy that we have a group of Nigerians who feel corruption should be fought by restructuring the justice system so that we have jury system. Jury system can help a lot, but for us who are not lawyers, we can't say we know all the issues involved in the jury system, but we believe it is an idea that is worth exploring. Like we are all aware, corruption has done a lot of damage to this country. Corruption will make Nigeria remain backward. Corruption will, hinder the development and progress of our country. Corruption, if left unchecked, is going to affect the prospects, the potentialities, and the orderly development of our country. And I feel our children and grandchildren will not forgive us if we refuse to do anything. We will keep trying to fight corruption, and Nigerians should key in the fight against corruption. This is because fighting corruption cannot be successful through the efforts of an individual, an agency, a ministry, or a department. In other words, the president and the vice presidents alone cannot fight corruption in Nigeria. EFCC, ICPC, NFIU, Code of Conduct Bureau, the Nigeria Police, Custom, Immigration, NDLEA, NAPDAC, all of them cannot fight corruption and other social problems affecting Nigeria without the active cooperation and collaboration of all stakeholders. Therefore, in fighting corruption, everybody must play a role because it is a very huge problem. Therefore, I feel this is going to be a time well spent. We will discuss, find out the merits and demerits of the jury system, the practicability and the bottlenecks in practicing the jury system in Nigeria, the opportunities and the challenges. By doing that, we will make progress, we will get ideas, and going forward, we will know where to pick up and give government ideas on how to go about it. On this note, I welcome you to this August occasion, and I hope at the end of it all, we will have beautiful ideas that will help us restructure the justice system in such a manner that the jury system will help us tackle corruption. Thank you very much, and you are welcome. Thank you again.
Thank you very much, Mr. Chairman, Executive Secretary of the Presidential Advisory Committee Against Corruption. You have been doing a great and fantastic job at the Presidential Advisory Committee Against Corruption. We see your efforts, we appreciate your support, sir. And we are believing that this event will also put us on the track towards getting it straight for us to all come together in a synergic form to push corruption out of Nigeria. And indeed, we can make progress as a nation, therefore. Thank you very much once again, sir. I think we now have our chairman, the chairman of the Jury Justice Directed Advocacy Initiative, Mr. Dave Ajetumobi. We'll take a few words from him. Thank you very much, sir. Mr. Dave, over to you, sir.
Okay, am I on now? Good morning, distinguished. Okay, our distinguished guests. I want to stand by the existing protocol, not on the. I do not stand in on the existing. I would rather stand by. I want to thank our guests for finding the time to be with us during this program. It was initially organized to be in-person program, but because of the reality of our time, it has to be converted to digital so we can. Let me appreciate the Lord, the Honorable Chief Judge Kadunan State Bench, represented by His Lordship, Honorable Justice Farious. I want to welcome the distinguished learnership, representatives of the Attorney General of Kadunan State, Chairman ICPC, ably represented by Dr. Noja, and Professor Rada has just delivered a fantastic address. We appreciate you, sir. Like Mr. Shomomo said, we have always had the best cooperation of PACA. We appreciate you immensely. I want to also appreciate Chief Paul Adiwu, the Clerk of the House of Rep Committee on Rules and Business, Mr. Chris Uma, the Chief of Staff to His Excellency, the Governor on Legislative Matters. I want to appreciate my comrades and colleagues, chairmen of the Kaduna branches of the NBA. Incidentally, in 2008, I was selected as the chairman of the most vibrant branch of the bar, the Kejaba. They call us the Tigers. And I've taught practically all the branches of the bar in Nigeria in the course of my activities in the NBA. NBA is very pivotal for legal reforms, institutional reforms in Nigeria. And I want to appreciate my colleagues for their cooperation, especially with regard to this program. Our aim, like the chairman said, is to have a healthy justice system. We don't want a situation. The judges are overburdened. I've been in this job for a few years now. By December, it will be 31. And I've seen what our judges go through in writing longhand, and it is easy to blame the judge. The judge is a human being. He had to write longhand. Thank God in Lagos now we have an auto recording system, but it's not everywhere that can be practicable or practicalized in view of the epileptic power supply. Some states may not even have the resources to do it. But if this jury system, we can start as an innovation to reduce the burden on the judges in the administration of criminal justice system, it will help a lot. Just yesterday, I learned that the musician R. Kelly has been convicted. It was verdict of guilt was returned by the jury in that case. It is appalling that some of us feel we don't have men of integrity in Nigeria. It's a self-indictment. I can tell you that we have millions of men of integrity. They are not coming out because there's no platform for them to manifest their attributes. I want to urge this meeting to support us in this jurisdiction so we can elevate the administration of justice in Nigeria to the standard that will be admirable to the rest of Africa. We've had our first outing with ND Ikeja. It was well attended. It was well received. We've had some other programs, including the one we had with Pakat in Abuja. This is one of the platform designed to sensitize and carry along everybody in this struggle. Sorry to use the word struggle. We are used to it in the for a better justice system in Nigeria. A lot of foreign investors will not invest if we continue to have this epileptic justice system and we continue our judicial bashing. Most of the problems are not with the judges. Some judges are overworked. So introducing this, we share the burden. The integrity of our justice system will be enhanced. Once again, I want to welcome everyone to this August seminar. I appreciate you for coming, and I believe that at the end of the day, we will have a concrete, tangible result that will help us in our push for the reform in the criminal justice administration system in Nigeria. Thank you very much.
Thank you, Mr. Chairman. It was quite an historic speech you gave, taking us to the background and putting us forward to know that we should put our best foot forward for, not just for our present, but also for our future, because indeed, we believe that the jury system, where we stand, the participation of the collective of the citizens will give us a better chance at fighting corruption. On this note, I want to hand over formally to the moderator, to one of the moderators, Mr. Idris Mohammed, who will be taking over from here. And well, I think it's time to hear from our special guest of honor, Honorable Chief Judge of Kadunan State, who will give us the goodwill message from the Honorable Chief Judge, who is also unavoidably absent today. Thank you very much. Mr. Idris, over to you. Please, it's your branch, so please welcome the Honorable Chief Judge. Thank you.
Thank you very much, Mr. Ogene Esomomo. Thank you for holding forth while we were out. I'm sorry it was due to network reasons that I couldn't join this webinar on time. Like you've just rightly pointed out, next we have the welcome remarks by the special guest of honor, the Chief Judge of Kadunan State, Honorable Justice Mohammedu Lawal Bello, who is ably represented here today by Honorable Justice Dairos Kubo. Please, sir, if you're on, please, sir, please go ahead and speak. Thank you very much. Honorable Justice Darius Kubo, sir.
Distinguished ladies and gentlemen, can you hear me?
Yes, sir, we can hear you loud and clear.
Oh, thank you so much. The Honorable Chief Judge of Kaduna State, Honorable Justice Muhammad Lawal Bello, would have loved to be in this program personally because of the passion he has in respect of improving the administration of criminal justice in the state. Unfortunately, the exigencies of his office will not allow him to participate, as he is presently in Abuja to attend Chief Judge's roundtable discussion. He has asked me to represent him. I am delighted to be here, and I must commend the organizers of this program for their thoughtfulness and the idea in bringing in this project, which will be discussed in this meeting to see how we can improve on the administration of criminal justice in Nigeria. The jury system, no doubt, as one of the speakers has said, will definitely help in improving the administration of criminal justice in Nigeria, but there is much work to be done, I think, because we have to look at the laws, look at the Constitution, and see the amendments needed to really bring in this innovation. It is quite an innovation that will help in the administration of criminal justice. It will also help in fighting corruption. Once again, on behalf of the Chief Judge of Kaduna State, who has a lot of passion in enhancing the administration of criminal justice in the state and the nation at large, I wish to welcome all of us to this very great occasion that is striving to bring in an innovation that has not been there before, but if embraced, will definitely lead us to the positive end. Thank you so very much, and I wish all of us a very fruitful deliberation and hope that at the end of this meeting, we will find a very, very lasting solution that will help us in fight against corruption. There is no need to belabor the issue. Corruption is endemic. Corruption has held the country backward for so many years, and if fought frontierly and frontically, we will be able to achieve, and then the development will come up. On behalf of the Chief Judge of Kaduna State, I once again welcome us to this very august meeting and hope that at the end, we will find very lasting solutions to some of these different problems. Thank you, and God bless.
Thank you very much, Milord, for your very kind remarks. We are indeed very grateful for the thoughtful remarks you have given to us. We'll now go straight up, and we're already taking the opening address by the chairman. And the next item on the agenda is special goodwill message from Professor Itse Sage, Senior Advocate of Nigeria. He is the chairman of the Presidential Advocacy Committee Against Corruption. Professor Sage has sent in his goodwill message, and it will be read by Mr. Ogene Esomomo. Mr. Ogene.
Thank you very much. I will be standing in Well, for Professor Sage to take his remarks, is unavailable to be present today with us, but is also being passionate about pushing for the introduction of trial by jury. Himself a constitutional lawyer and indeed one of the brightest brains Nigeria has produced in the legal profession. His remarks: the imperative of the jury system for Nigeria, a goodwill message from Professor Sage, SAN, chairman of PACAC. Although there is no state in Nigeria currently operating the jury system in the administration of criminal justice, in Lagos, the jury system was operating with regard to criminal matters up until 1976, when it was abolished. I personally supported the abolition for various reasons, but the most important one was my belief that laymen juries could easily be influenced or subjected to other people's interests and instructions in making their decisions. On the contrary, a judge being learned in law was more resistant to any outside influence than a layman. In addition, a judge by his status and position would more likely uphold the integrity of the judicial system. Again, since the judge decided the legal issues whilst the jury decided on the facts, adopting the jury system will further increase the duration of criminal cases concerning corruption and unfortunately, yes, a lot of established juries relied upon to uphold the integrity of the judicial system. They appear prone either to bribery and corruption or bias as a result of their relationship with the defendants before the courts. An example of this is the increasing demonstration of esprit de corps between trial judges and judges who are defendants before the courts. It would also appear that technical legal knowledge is being used as a barrier to the attainment of, thereby making knowledge of the law a negative factor in the determination of guilt or innocence in criminal cases, particularly in corruption cases. It is becoming increasingly clear that there are many judges who do not make the attainment of justice the sole objective of their judgments. It is therefore necessary to involve laymen in criminal trials whose only endowment is a sense of what is right or wrong, what is just or unjust, with no technical cobwebs in their minds. There is also safety in members. 12 solid Nigerians with good backgrounds and the determination to do justice can rarely be wrong. I therefore urge participants at this seminar not only to proffer suggestions to improve the draft bill produced by the organizers of this webinar, but also to join in the efforts to ensure its fast and smooth passage through the National Assembly and the State Houses of Assembly, since this is neither a matter on the exclusive legislative list or in the concurrent list. It is therefore a residual matter subject to states' exclusive jurisdiction. I wish you a very successful deliberation. Professor Sage, SAN, Chairman PACAC.
Thank you very much, Mr. Ogene Eshomomo. As usual, Professor Sage presents his thoughts very lucidly, and he has passed on his message to this webinar. Before we go on, may I just quickly acknowledge the presence within this webinar of several people. The chairman of the Barnawa branch of the Nigerian Bar Association, Mr. Abdullah Yaya, SAN, you're welcome, sir. Former National Welfare Secretary of the Nigerian Bar Association, Mr. Adeshino Adegbite, you're also welcome. Mr. Elisha Kura, SAN, is also going to be giving us his remarks. Subsequently, is also with us here today. Thank you very much. Dr. Hazard Abila will be representing the keynote speaker. Professor Mohammed Tawfiq Laden is also here with us. The Secretary of the Nigerian Bar Association, Mr. Maxwell Kyong. You're welcome, sir. We'll continue with the recognitions as we see them. But right now, we would be taking special remarks by the Attorney General of Kadunan State, if she's here present with us, or our representative. Anyway, so I'm sure as soon as she joins us, we will take our remarks. But as it is now, the next item on the agenda is the keynote lecture by Professor Tawfiq Ladan, the Director General of the Nigerian Institute of Advanced Legal Studies. He is here represented by Dr. Hazard Abila. Dr. Abila, sir, you're welcome.
Thank you very much. My name is Dr. Abila Azad. I'm a senior research fellow with the Nigerian Institute of Advanced Legal Studies. I'm here to represent the Director General, Professor MT Ladan. We at the Nigerian Institute of Advanced Legal Studies are highly gratified to have our Director General invited to be the keynote speaker in this symposium organized by this very important organization. We do not take it for granted. As a matter of fact, the Nigerian Institute of Advanced Legal Studies has been in the forefront of programs of government targeted at reforms in the criminal justice sector in the country. And we have also participated actively in various activities of government, seeking means to solve the problem of corruption in this country. And to this extent, I can say that we have donated, let me use this word humbly, some of our brightest minds or brains to organizations such as ACAC, the ICPC, and other organizations of government in Nigeria. And we are delighted that this organization has invited our DG to be part of this discourse today. Professor MT Ladan would have loved to be here personally at this webinar to deliver this keynote address, but the exigencies of office and his activities will not permit him to be here. He sends his apologies to the organizers and all participants. Well, the shoes of Professor MT Ladan are too huge and large for me to step into, but a job has to be done, and the mantle fell on me to do the job on his behalf. And I would say also, I'm humbled at the opportunity to be here in a representative capacity to deliver this keynote address. It is my prayer and belief that at the end of this webinar, practical steps will be taken to ensure that there are reforms in the administration of criminal justice in Nigeria, which will enhance and promote the fight against corruption in the country. Now, more of introduction. So Nigeria is reputed to be the largest economy on the African continent. This is a fact. We have a GDP of about 410 billion United States dollars as of 2019. We also have earnings of about 65 billion United States dollars in exports free on board, about the same year in 2019. Now, this revenue, if well utilized, is capable of developing our country into one of the flourishing economies of the world and making our people prosperous. Unfortunately, however, 60 years since independence in 1960, the indices of development are very scant in our country, Nigeria. And we have one of the worst infrastructure on the African continent, according to the African Development Bank. Most of our infrastructure are broken and amongst the worst on the African continent. We have high levels of unemployment, and poverty is so pervasive in the country. In 2014, the World Bank estimated that about 70% of Nigerians lived on about $1.25 per day, or even less per day. And that Nigeria was the country with the third largest population of the poor in the world, where about 7% of the poor lived. This was reiterated again in 2015 by the World Bank, wherein it was estimated that by 2018, Nigeria would be the poverty capital of the world. The World Poverty Club predicted this in 2018, that Nigeria will overtake India as the country with the most people in extreme poverty. We did not take this too seriously, in my own opinion. And in 2018, this prediction, or shall I say prophecy, came to pass. And it was reported that about 87 million Nigerians, or close to half of the population of the country, lived on about 1.90 United States dollars a day. Now it is estimated that from independence in 1960 to 2005 alone, about 20 trillion United States dollars have been stolen from this country. This was the estimate by Oxfam. If you read Oxfam, Nigeria inequalities in numbers, you will see these statistics that about 20 trillion United States dollars. When I saw the figure 20 trillion, I got frightened. Now, this money, when stolen, is often stored away or frittered away to developed countries, where it helps in developing the economies of those developed countries while impoverishing our own country. Without a doubt, this amount of money is almost close to the annual budget of the United States of America of $18 trillion in 2012. And this could fund our annual budget of about $27 million per year for many years. You could imagine if $20 trillion is injected into the Nigerian economy. Imagine the extent or level of development that will have taken place in this country. So the amount of money is capable of making government to meet its responsibilities to the people, of providing infrastructure. Today, Nigeria is going all over the world borrowing money in order to build infrastructure. If this money was available to the country, not stolen, we wouldn't have been going to China and other places to look for money. It would have been sufficient to develop the country into one of the leading economies in the world. And that is why today we have broken down infrastructure, broken down healthcare delivery services, and so on and so forth, when we have the capacity to be better than what we are. Now, the significance of the problem of corruption in this country can better be appreciated if we consider the fact that the potential for Nigeria to develop exists in the country. It is reputed to be the country with the largest agricultural output on the African continent and number 25 in the world. We earn about 57 billion United States dollars annually on oil revenues. And without a doubt, we can say that corruption has been the prime economic malady of this country and continues to be one of the obstacles hindering the development and prosperity of this country. And reason why our country continues to be one of the basement countries in Transparency International's annual corruption perception index, which is not a good testimony for this country. So the critical question is, how do we get out of this logjam? How do we get out of this problem? Without a doubt, there are so many ways that Nigeria can utilize to move itself out of this problem. But one of the key players, one of the most important players that will ensure that the problem of corruption in Nigeria is resolved is the judiciary or the criminal justice sector. So the question is, why is it not happening in the country? We have a lot of initiatives in the criminal justice sector. We have a lot of legislation. So, but what has been the efficacy of the criminal justice sector in addressing the problem of corruption in Nigeria? And what reforms are necessary or required in the criminal justice sector to make the fight against corruption in Nigeria more potent? Now, Nigeria has a long history of legislating against corruption. At independence, we all know that two principal legislation operated in the country, and this legislation were the criminal code and the penal code. They contain offenses, deal with offenses, including offense of corruption. But as of that time, corruption was not considered a more serious problem in its incidence and effect than other criminal offenses. So the provisions on corruption in this legislation deal mostly with the offense of gratification. And they do not take care of the modern trends, modern sophistication of corrupt practices as we now see them in this country. And also both legislation did not establish any institutional framework champion the fight against corruption in the country. Now, in view of the provisions of the 1999 Constitution, Section 15, which obligate the state to abolish all corrupt practices in the country, and the glaring inadequacies of the criminal code and the penal code to effectively deal with the various dimensions of corruption in Nigeria, the country enacted other pieces of legislation to address the various manifestations or dimensions of corruption in the country. This legislation include the Corrupt Practices and Other Related Offences Act, the Economic and Financial Crimes Commission Establishment Act, the Advanced Fee Fraud and Other Related Offences Act, the Money Laundering Prohibition Act, and so on and so forth. So the problem is not a dearth in corruption or in legislation. We have adequate legislation that should ordinarily deal with the problem of corruption in Nigeria. Adequate legislation exists. So, but what is the problem? And in my own opinion, it is the problem of implementation or enforcement. And that is where the judiciary comes in, the administration of criminal justice sector comes in. Now, before 2015, the criminal justice sector in Nigeria was regulated by the Criminal Procedure Act, the CPA, and the CPC. These rules of procedure rather guided conduct of criminal trials in Nigeria for several decades. But as the world becomes dynamic and changes, it is apparent that these rules of procedure do not adequately respond to the changes and the dynamics of an evolving world. And this resulted in a lot of problems in the administration of criminal justice in Nigeria. We had trial delays, we have inefficiency in the system, and so on and so forth. And over time, Nigerian society watched with disgust as some trials of corruption cases in the country were frustrated or compromised. I will cite just one or two examples. In 2009, the Federal High Court in Asaba, Delta State, for no plausible reason, dismissed at interlocutory stage all 170 count charges filed by the EFCC against James Ibori, a former governor of Delta State, who was standing trial for looting more than 85 million United States dollars, funds of the state. In 2007, that is 2 years before the Ibori saga, a Federal High Court in Port Harcourt in Rivers State granted an order of perpetual injunction restraining the investigation and prosecution of Peter Odili, the former governor of the state, over allegation of embezzlement of about 100 billion naira of state funds. Many politically exposed persons in Nigeria have used interlocutory applications, such as stay of proceedings and so on and so forth, to scuttle their trials for many years. An example is the case of Chief Joshua Darie, former governor of Plateau State, who secured an order of interlocutory stay of proceedings to frustrate his trial for many years. He journeyed from the High Court to the Court of Appeal to the Supreme Court. And the Supreme Court ordered that he must face trial. He had to come back to the High Court and commence the proceedings all over again until the same was determined by the High Court. And this took so many years. And that was why the Supreme Court in Olagunju versus Federal Republic of Nigeria and Darie versus Federal Republic of Nigeria decried this lengthy period of trial due to unnecessary applications by these politically exposed persons. Now, the observation learning theory of crime postulates that what we learn is obtained more by observing others, and that this is even more efficient than learning through direct experience. We learn more by observation. Many Nigerians observe how some of these politically exposed persons accused of corruption become suddenly wealthy from nowhere. They amass so much wealth, become so powerful, and they do everything possible to frustrate their trials. And in many instances, many of these politically exposed persons appear to go scot-free. No consequences to their actions. And many Nigerians observe some of these things, that people who are perceived to be corrupt go unpunished, and largely due to the efficiency in the court system in the country. And this motivates or inspires a lot of other people to emulate this corrupt behavior. And that is why we continue to see corruption multiplying by the day, because there is a belief that you can be corrupt in this country and nothing happens to you at the end of the day. So the general outcry of lack of progress in the criminal justice system in Nigeria, and how this has impacted negatively on efforts to curb corruption in the country, has led to advocacy for a review of the administration of criminal justice system in the country. After many years of this review, the Administration of Criminal Justice Act, ACJA, was enacted in 2015, bringing a new dawn in the criminal justice sector in the country. Now, the ACJA, without a doubt, contains very innovative provisions, beautiful provisions, which, if well implemented or enforced in this country, will go a long way in helping the criminal justice system in the country. It ensures that there are provisions on efficient management of criminal justice institutions. Also, it ensures that there are provisions for speedy trial day to day. It abolishes stay of proceedings, and so on and so forth, which to my mind is a plus to the administration of criminal justice in Nigeria. However, the provisions of ACJA cannot deal with the court structure, which is one of the most fundamental issues that have to be looked into if we are to give more bite to the fight against corruption in the country. Now, what is this court structure? The judicature is a constitutional issue in the sense that all the courts, our judicial power can be said to reside in the courts established by the Constitution for the Federation. Now, in section 6 of section 5 of the Constitution, these courts are listed as follows: the Supreme Court, the Court of Appeal, the High Courts, the Federal High Court, State High Court, and High Court of the Federal Capital Territory, the Sharia Court of Appeal of the various states, and the customary courts of appeal of the various states. So these are the courts that have been created by the Constitution, and these are the courts that can actually adjudicate on matters. These are called courts of record. Now, from the above listed courts, only the High Court is the court of first instance. The Supreme Court, the Court of Appeal, Sharia Court of Appeal, and Customary Court of Appeal are all appellate courts. So it can rightly be said that only the High Court is a trial court. Now, all the specialized legislation on corruption, which have been listed above, the ICPC Act, the EFCC Act, the Money Laundering Provision, and so on and so forth, they all vest jurisdiction on the High Court to entertain criminal matters in respect of proceedings, in respect of offenses created in the legislation. Now, the High Court of the various jurisdictions in Nigeria is duly constituted if it consists of at least one judge. This is a constitutional provision. So we can say that the High Court is constituted by only one judge. What this means is that in trials, all trials at the High Court, only one judge sits to determine the matter. Now, what is the implication of this? Within our society, in the context of the Nigerian society, the High Court being constituted by only one judge is open to so many things, a lot of things. I've heard in the goodwill message of Professor Sagi, he said that the High Court judge is able to uphold the integrity of the judiciary. I agree completely. But within the Nigerian context, we do not have an ideal situation in the country. And this is an issue that is a matter of common knowledge. It's the public domain. That a High Court judge sitting alone is more susceptible to influence, compromise, or even outright manipulation. So this leaves the court system in Nigeria at the trial level vulnerable to so many things, which can defeat the cause of justice and hinder the fight against corruption in the country. There are a lot of instances, they abound in this country, where the NJC has had to take disciplinary actions against some of the judges of the High Court on account of betrayal of integrity. Like the chairman initially said, we have a lot of many High Court judges who are men and women of high integrity. No doubt about that. We have them in abundance. But there are equally others who have integrity deficit. So the NJC has had to wear the big axe against many on account of betrayal of integrity. Now, where a trial judge is compromised, the entire judiciary, the integrity of the judiciary is put to question. Where one trial judge is compromised, the integrity of the judiciary is put to question. Many politically exposed persons in this country who ordinarily should have been serving jail terms for corrupt practices are today walking the streets free, largely due to the weakness of the court system in the country. An example is a case of one John Yusuf, which we all know, who was accused of embezzlement of 33 billion naira. He was sentenced to 2 years imprisonment, which is scandalous, or to pay a fine of 750,000 naira cumulatively. This fellow easily paid the fine. We are talking about 33 billion naira. Easily paid the fine and walked away. This is a classic example of abuse of discretion by a trial judge in favor or for the benefit of a politically exposed person. And if the problem of corruption must be tackled in this country, the judicial sector must play a key role. But however, the problem of bench trial, that is a trial by one single judge, has left the judiciary susceptible to compromise, manipulation, and outright intimidation, as stated earlier. And this has affected its efficacy in serving justice and contributing to the fight against corruption in Nigeria. Now, this gives validation to calls for reform in the administration of criminal justice, particularly as it affects bench trial. And one of these calls is what we are here all gathered together to discuss. How do we ensure a reform that will be effective and efficient and gain the confidence of the people? And one of these calls is for a jury trial. And that is why we are all gathered here. Now, the jury trial and its steps in the fight against corruption in Nigeria. I said that criminal trials are guided by some fundamental principles. Number one is quest for the truth. Each trial is an attempt to establish the fact upon which a final decision will be made. It is interrogation of the facts to arrive at the truth. So this is one of the underbellies, the fundamentals of a trial. Secondly, in every criminal trial, it is expected that it is aimed at minimizing the risk of convicting the innocent. This is very important. So a balance has to be struck between the need to convict the guilty and safeguarding the innocent. And this safeguard would be impossible unless there is established safeguards based on community standards. Based on community standards. One other fundamentals of criminal trial is public confidence. The legitimacy of every trial is rooted in public confidence in the system of adjudication. The criminal justice system, therefore, must meet acceptable community standards. Where a criminal trial is not rooted in public confidence, it loses its legitimacy. And because it must meet some acceptable community standards, it requires community participation. And this will ensure the acceptability of the process and accountability by persons who are in charge of the process. Another fundamental is fairness and justice. One of the essential requirements of criminal justice is that it must be fair, certain, and consistent, both in law and procedure. The principles of fairness require that justice must not only be done, but seen to be done. In this wise, all the parties involved in the trial must perceive that the trial was fair. Trial also has to be, there has to be efficiency in the administration of criminal justice. It is efficiency necessarily would produce just outcome. Where there is efficiency, it's more likely that the outcome will be a just outcome. There must also be effective communication. That is, the proceedings must be conducted in a manner that resonates with the people, that the people understand. It is when the people participate that they understand the proceedings and accept its outcome. It must also be open. I don't want to waste much time here. Now, these principles also anchor the jury system in criminal trial. It also bears the jury system in a criminal trial. In the United States of America, where we copy most of our things from, it wasn't an easy struggle to get the jury trial to be accepted in the country. It took a long time. The recognition came did not come until the 6th Amendment. It was the 6th Amendment that guarantees to the citizens the right to face their trial by way of jury trial. And this right inures the citizens for an offense which attracts a penalty of at least 6 months. So it is not all the trials that citizens are entitled to do trial. It's a trial involving offenses that attracts penalty of not less than 6 months. Now, the jury trial, the citizens are guaranteed trial by a jury, or each citizen is guaranteed trial by jury of one's peers. One's peers. And this has been interpreted to mean a trial that consists of people who are a fair representation of the section of the community. Fair representation of the section of the community. So therefore, a jury trial is a trial system where lay people are chosen from a pool of persons and empaneled to determine guilt or innocence by ascertaining the facts and applying the law as interpreted by a presiding judge. Now, this task is an onerous one, but I'll look at it from 2 perspectives. The duty of the jury is to listen to evidence and arguments presented by the parties, weigh these arguments, and arrive at a consensus. And once they arrive at a consensus, they pass a verdict of guilty or not guilty. So the task of the jury is to listen to the facts, and based on community standards, they weigh these facts based on these community standards and arrive at a verdict whether the defendant is guilty or is not guilty. Now, the jury, being lay people, do not interpret the law. They have nothing to do with the law. They are concerned with the facts, not with the law. But they rely on interpretation of the law as made by the judge to arrive at their consensus. And if they arrive at the consensus, they refer the sentencing to the trial judge. So the jury trial is anchored on the age-old principle of law, or principle rather, we can say on age-old principle that crime is an act against the people and not against the state. Crime is an act against the people, not against the state. In our present structure in Nigeria, crime is viewed as an act against the state, not against the people. The Administration of Criminal Justice Act, ACJA, has, however, tried to introduce restorative measures in the Administration of Criminal Justice so that victims of crime can be compensated for the crimes against them. So trying to bring it closer to the people that crime is an act against the people. But by and large, in our Administration of Criminal Justice in Nigeria, crime is viewed as an act against the state and not against the people. But the jury trial seek to drive home the fact that any crime is an act against the society and its people. Therefore, the people under democracy must be empowered to decide when their laws have been violated and the appropriate sanction to be applied to such violation. If it is crime against the society, against the people must be empowered to make the decision whether or not their standards, their laws have been violated and what the consequences of such violations are. Now, in the present system, in the present structure in Nigeria, the judiciary is a kind of separated from the people, in that the people have no say in determination of who decides what their standards are and when these standards are violated. The judge is appointed by people who are detached largely from the community. And so you see limited participation of the community, of the people, in determining whether their standards have been violated. And in the jury system, the jurors are not just they are not only appointed, they may also be elected. So the people have a say in who sits to determine whether their standards have been violated. And this is very, very profound and important. Now, in order to ensure fairness and the integrity of the jury system, the prosecution and the defense also play important roles, as they are also involved in the process of selection. They may object to any juror whom they feel lacks the requisite integrity or what it takes to be a juror, to participate in a jury trial. Now, some arguments have been canvassed against the utility of the jury system in criminal trials. Because it is my belief that the jury trial, bringing in the people to participate in trials or in trials of corruption cases, will go a long way in advancing solutions to the problem of corruption in Nigeria, which has festered for too long. But some arguments have been canvassed against the utility of this system. It has been argued that in criminal trials, that criminal trials are becoming more complex and technical, and that jurors may lack that technical capacity to be able to appreciate the facts. And to that extent, that the jury trial is not suitable to the system, our own system. Well, these are arguments. Yes, indeed, criminal trials are becoming complex. There's no hiding from this, and also scientific, no hiding from this, no running away from this. But the important thing is to understand that jurors, like I said earlier, deal with the facts of the case and not with the law. And in the field of law, no facts may be too complex for lay persons to understand, particularly lay persons who have some form of education, even if not in areas related to law. They can understand the facts as presented. And moreover, the facts are related to their community standards. So the argument that criminal cases are becoming complex and scientific and facts are becoming complex do not stand, in my own opinion. Moreover, since jurors are elected or selected, and both the prosecution and the defense counsel have a role to play, jurors who have demonstrated ability, demonstrable ability to appreciate issues can be selected to sit as jurors. So since it is a pool, there are lots of people involved. So we choose those whom we feel have the capacity to appreciate issues. So this, in my own opinion, cannot stand. It is not a reason why the jury system cannot be applicable in Nigeria. It has also been canvassed that since jurors do not ask questions during trials, unlike a judge that may put across a question, that jurors do not ask questions, and they are not always assisted to get access to relevant evidence and exhibits. And also, they are not required to give reasons for their decision. Therefore, their verdict may not be rational. They do not ask questions. They are not always assisted, and they are not required to give reasons for their decision. It is argued that in a lot of instances, juries are found to have acquitted some defendants when the evidence establishing guilt is overwhelming, and that this makes the criminal to go unpunished, therefore defeating the cause of justice. The jury trial is also said to help, not to help in mitigating delays in trial and the cost of trials, as so much time is spent to explain to the jurors in order for them to absorb the evidence and to also explain to them the applicable law, and that this contributes in delays, inordinate delays of trials. Well, admittedly, the jury trial may not be perfect. It has its drawbacks as listed above, rightly or wrongly, but its utility cannot be overlooked. It cannot be ignored, especially in the quest to confront the monster of corruption in Nigeria. Now, we said the jury consists of a number of persons. The standards and values held by each individual member of the jury is representation of the general community. So the jury reflects the community. The standards and values of each juror is a reflection of the community. Therefore, in arriving at this decision, the jury, being composed of a number of persons in America, Australia, usually they are 12 in number. So in arriving at this decision, the jury leverages on a wide diversity of experiences of life, which showcases what is called democratic structure. So it leverages on wide experiences, not the experience or knowledge of one individual, but experiences of a larger group. So this showcases democratic structure or norms. Now, it is also a way, like I have highlighted earlier, in which the people participate in the administration of criminal justice in their community and providing a link between the community and the judicial system or the legal system. So the jury ensures that the legal system is not alien to the community, but truly represents their values and their standards. The sociocultural perspective on corruption presumes that no singular culture is applicable in all societies. Each society have their norms, their standards. Therefore, cultural and social phenomena are relative rather than absolute. So what is right here may not necessarily be right in another place. They are all relative, not absolute. And what is acceptable and proper in one society, as proper conduct in one community or one society, may not necessarily be regarded as such in other societies or communities. Thus, every society molds its values and its norms and its standards. The conduct of individuals is to a large extent influenced by their sociocultural circumstances. It can therefore be said that the culture of corruption in Nigeria is festered by the nation's societal values, and only the people of Nigeria can change it. Gone were the days when our values oppose corruption. Those days when a child brought home something, the parents will ask, where did you get it from? But these questions are not being asked anymore. Our values have changed. We are inclined towards making money by any means. So our values have changed. And that is the context in which the next generation in Nigeria is coming up. The values of money. Everything is about money. And everything can be settled. That is the culture that we are cultivating for us as a people. Almost everything is settled in Nigeria. Examination results are settled. So many things. So we are responsible for building our customs, our standards, our norms, and our values. And the jury system can help towards nurturing a culture of honesty in this country. And it will help in building our society. So there is no gainsaying that the ordinary man in Nigeria, the man on the street, is the major victim of the problem of corruption in the country. Ordinary people. They are the ones who are being denied healthcare services. The people who are important in this country, who are not ordinary people, fly to India, fly to Germany when they have medical challenges. So it is the ordinary man on the street that has to bear the brunt of the problem of corruption in the country. It is the ordinary person that is denied development. It is the ordinary person whose economic well-being is decapitated by the problem of corruption. Now, the jury system, which is community-based or community-based system of adjudication, can provide a veritable platform upon which the ordinary people can participate in sanitizing the country from the cancer of corruption. The outcome of many corruption cases brought against politically exposed persons in Nigeria could have been different, probably, if tried by the jury instead of the bench. Probably had Lucky Ibinedion or John Yusuf, both accused of stealing billions of naira, been tried by a jury, they would not have escaped with only a slap on the wrist punishment of party terms as a punishment for their corrupt conduct. The compromise by the bench, by the politically exposed persons, has created a trust deficit between the bench and the general public in Nigeria. And this often results in distrust of the judicial process. Remember, I said every trial must be rooted in confidence. Now, trust in the judicial process will be restored only if the people participate in the process. Today, many people do not trust our judicial system. They believe that any big man that is charged to court may escape. He may walk his way through and evade justice. So there is this large, big distrust between the general public and the judicial system. Now, the jury system is not totally alien to Nigeria. It has existed before in this country, especially in Lagos, until 1976, when it was discarded by the country, by the military government from the country's law books.
Sorry,
and although, yes,
sorry, please, you just need to round up now, sir.
Yes, I'm rounding up. I'm rounding up. I'm
rounding
up now. Yes, sir. So it existed before until 1976 when it was discarded. Now I said, although the enactment of the Administration of Criminal Justice Act in 2015 introduced some innovative provisions which have boosted the fight against corruption in Nigeria, the fight could be better enhanced if the country reintroduces or adopts a jury system which promotes fairness, mitigates judicial corruption, ensures citizens' participation in the process. Now, by way of conclusion, this may not be easy, and that is why I appreciate the advocacy of this organization in pushing for reforms. And this will start with constitutional reform, because constitutional amendment, because by virtue of the provision of Section 6 of the Constitution, the jury is not in contemplation. So there must necessarily be a constitutional amendment to ensure that this is done. So I said effective, and power of conclusion, effective and efficient judicial system is important in curbing the scourge of corruption in Nigeria. The jury system is practiced in some developed countries such as the United States and Australia with great success. The system has improved the effectiveness and efficiencies of the judicial systems in these countries. Nigeria copied the democratic system of governance practiced in the United States, but it only did that partially. It copied the presidential system, bicameral legislature, but failed to copy its judicial system, despite the glaring benefits and effectiveness. This omission blights the administration of criminal justice in Nigeria and affects its potency in addressing the problem of corruption in the country. It is my belief that from the way forward from today, that there will be a massive push to ensure that this system is introduced in Nigeria so that we can finally bid farewell to this monster of corruption that has besieged our nation for many years. I want to thank you for the platform given to me. I want to thank you for listening.
Thank you very much, Dr. Abila Hazard, for that well-researched paper on the topic of this seminar, which is the role of the jury system in restructuring the criminal justice system for efficacy in fighting corruption. You would all agree with me that Dr. Abila has done immense justice to the topic. Just by way of summary, he went through an historical perspective on corruption and gave us required reforms that needed to be done. He identified the legislations enacted in Nigeria to tackle corruption up to the Administration of Criminal Justice Act. He gave instances of where the court systems were vulnerable to corruption trials and suggested reforms for an effective and efficient trial using the jury system. He furthermore looked at the pros and cons of the jury system and agreed that the jury system would be effective in combating corruption. We'd like to thank you once more, sir, for that well-researched paper. You have really done justice to it. We're most grateful. Just by way of introduction, I failed to do that when I started. My name is Idris Mohammed. I'm the immediate past secretary of the Nigerian Bar Association Kaduna branch. I'm not the only person moderating today. We also have with us Malam Ibrahim Dan Alilu. He is the director of Frontline Media Consultants and executive director of the Ubasani Foundation. You will be taking over the proceedings from me now and continue with the rest of the agenda of this seminar. Malam Dan Alilu, sir.
Yes. Yes.
Okay, perhaps Malam Dan Alilu is not with us yet. We'll now be going on immediately now to remarks by Honorable Emmanuel Kantiok. He is the chairman of the House Committee on Judiciary of the Kadunan State House of Assembly. I don't know if there's anyone here representing him, because I can't seem to find him within the list of the people attending this seminar. Okay, while we wait for Honorable Emmanuel Kantiok, let's immediately go to the guest contribution by Professor Bolaji Owasanoye, Senior Advocate of Nigeria. He's the chairman of the Independent Corrupt Practices Commission and is here represented by his Chief of Staff, Dr. Isa Onoja. Dr. Isa Onoja, you have the floor, sir.
Thank you very much. Good morning, everyone. My Lord, the Chief Judge of Kaduna State, ably represented, the Chairman of the occasion, Professor Isarada, the Executive Secretary of PACAC, may I humbly crave your indulgence to stand on the protocol earlier established at the beginning of this program. Professor Bolaji Owasoye, the chairman of ICPC, is out of jurisdiction, and that's why he's not before us this morning. He has asked me to send his regards and also extend his apologies. He has also directed me to make a few observations in relation to the presentation made this morning by the previous speakers, particularly the keynote address by Professor Mohamed Tawfiq Ladan, the Director General of NICE, who is ably represented by Dr. Azad. The remark of Professor Bolaji Owasoye, which I now proceed to make, is titled Implication of Introduction of Jury System in the Criminal Justice System of Nigeria in Fighting Corruption. It begins with a quotation, and the quotation goes as follows. Trial by jury is not only the distinguishing feature of our legal fabric as compared with that of our other nations, but it is the crowning piece of our jurisprudence, evolved through the weary length of many centuries and gradually superseding older forms of trial that were far more popular in the earlier periods of their contemporary existence. It has developed into an institution of marvelous efficiency, and it is regarded by many as the apotheosis of the judicial investigation and determination of disputes. This is a quotation from a journal that was published in 1919 by an American scholar. It does not refer to the Nigerian criminal justice system, but the American criminal justice system. But the quotation raised a number of burning questions. And the questions include the following. Is jury trial a part of Nigerian legal tradition? In this context, our legal tradition includes indigenous legal traditions of the various ethnic groups in Nigeria, the received legal tradition that our colonial masters bequeathed to us, and Islamic legal tradition. Second, what are the likely constitutional amendments and other modifications to the composition of criminal courts that must take place before jury trials can be introduced? 3, if jury trials are marvelously efficient in England and the United States, would the same be the case in Nigeria? 4, what are the implications for prosecution of corruption cases if jury trial is introduced into our current criminal justice system? We have presented the above questions as food for thought and have not provided much answers in the hope that stakeholders would consider these questions going forward. Now, some implications for jury trials in corruption cases. This includes the need to amend the 1999 Constitution to change the composition of courts exercising criminal jurisdiction. This is similar to what Dr. Azad said earlier on. 2, the need to amend the High Court laws of states, Magistrate Court laws of states, etc., to alter the composition of courts when exercising criminal jurisdiction. 3, the need to amend criminal justice and other procedural legislations to provide for jury selection procedure and other procedures that are peculiar to jury trials. Then the need for investment in court architecture and infrastructure to ensure sanctity of environment where jurors are accommodated, generally to ensure that jurors are not tampered with. Finally, I think we are all familiar with various video clips trending on social media pertaining to vote buying in Nigeria. In one particular one, there was a queue of voters and somebody started counting. He said 1, then he said 2, 3, suddenly 3 became 20, and they went on and on. But those on the queue were not up to 100. And what he counted was more than 150. So these are some of the realities that we need to consider when reforming our criminal justice sector. Observations and conclusions. Now, Section 4, Sub 1 of the Administration of Criminal Justice Law, 2017 of Kadunan State domesticates the provisions of Section 1, Sub 1 of the Administration of Criminal Justice Act 2015, where it provides that the purpose of the law is to ensure that the system of administration of justice in Kaduna State promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of society from crime. So our view is that we should consider the implications of jury trials for efficient case management, speedy trials, and protection of society from crime, including corruption. Now, if there have been any error in this presentation, those are mine, but any good points there are those of Professor Owasoi. In summary, he has asked me to deliver a message of support to the organizers of this symposium, to commend their courage, to commend their industry, because we're all stakeholders in the fight against corruption. But in fighting corruption, we must examine what we are presently using to see the extent of reform that we need to make it more functional. The reforms needed in terms of the legal infrastructure, or do we, as Nigerians, do we have to ask ourselves very inconvenient questions about our tolerance for what ordinarily should not be tolerated, the glorification of wealth, and all other negative vibes that does not speak well of us as a people and as a nation. Thank you for your listenership.
Thank you, Dr. Isa Onoja, for sharing with us the thoughts and the guest contributions of both Professor Bolaji Owasonoye, the Senior Advocate of Nigeria and Chairman of the ICPC. We truly appreciate those contributions. May I now call on Mr. Elisha Kura, Senior Advocate of Nigeria, Chairman Ariwa Lawyers Forum, for his own contributions, sir. Leonard Silk.
I hope you can hear me.
Yeah, yes, sir, we can hear you loud and clear, sir.
Okay, thank you. Now, before I start my own contribution, may I just make a few comments on what my younger brother, Dr. Azad, as presented. In fact, one of the issues he mentioned was the contention that a high court judge, a single high court judge presiding over a matter is exposed to so many problems in the form of inducement. Now, I wish to state that that may not be entirely correct. And the reason is not far-fetched. We've seen tribunals that sit in panels. Panel of 3 judges, sometimes 5, and they are also influenced. So I don't think the issue is how many people sit in a panel. One person full of integrity who could give us a very good result, more than a panel that is prone to influence. Secondly, even the jury are not immune from influence. They don't have that immunity to be influenced. The reason is that if you look at within our context, the Nigerian context, I mean, the poverty level of Nigerians can induce so many influences. In fact, there are instances where it is not poverty, but something I may call it greed. Because you find out that somebody who you feel is comfortable, but will be, when a bribe is offered, he takes. So I don't think it's about that. And then secondly, the educational level of our people. Is it such that the jury system can work effectively? Take, for instance, there are cases that are in various villages. So what is going to happen to cases tried there, they are criminal, and they are also corruption cases too? Because you know the issue, the term corruption is relative. Let's not look at it from the context of politicians. No. We should look at it from a wider perspective. So if the matter is in one village, where, for instance, the customary courts are, and you know the customary courts in this state are manned by lawyers, and the language of those courts is English, and the local people there may not understand English, it's Hausa they speak. So it is the interpretation that is done to them that they pick. So are we saying that the jury system is also applicable in that situation? No, these are, like I said, I commend the organizers. These are just thought-provoking issues that we are springing up. Because even in developed world where this system started, it did not evolve in a year or 2 or even a decade. In fact, one thing about the jury system is that it has frequently been observed that one of the most interesting things about the jury trial is how infrequently it takes place, given the enormous significance with which it is vested by the public, politicians, and the legal profession. I'll give you instances. In England, trial by jury takes place in just over 1% of criminal cases, 1%. In Scotland, the equivalent figure is just 1%. Yet the system manages to maintain immense political and symbolic importance. So what I'm saying is that even in countries that want to emulate, jury trials are restrictive. If 1% of the criminal matters handled in this country by jury trial is introduced, we cannot say that we have made immense progress. Just 1%. as it happens in England and Scotland that I've just mentioned. Now, the jury trial has been traced to the Magna Carta, though that's debatable. Some writers and academicians have argued to the contrary. But it began in the form of a grand or presentment jury with the role of inquest, and was started by Frankish conquerors to discover the king's rights. That's its origin. King Henry II regularized this type of proceeding to establish royal control over the machinery of justice, first in civil trials, and then it entered into criminal trials. So trial by jury was not employed, at least until the reign of Henry III. So I'm just giving you a historical perspective to tell you that it is not a trial that we just send a bill to the Kadunan State House of Assembly and it's passed and it takes place. It will not take place in that manner. Until the reign of Henry III, in which the jury was first essentially a body of witnesses called for their knowledge of the case. Not until the reign of Henry VI did it become the trial by evidence. It was during the 17th century that the jury emerged as a safeguard for criminally accused. That was in the 17th century. So it took a large chunk of period before this system evolved, and that we are even admiring it now, that it is necessary for it to be introduced to curb corruption. And I have my doubts whether it can curb corruption. I will come to that. Now, like my friend Dr. Azad has said, my younger brother, the jury trial in this country is not, we can't start it by sending a bill to the National Assembly of States. We'll start it first by the constitutional amendment, as Professor, the chairman of ICPC has said. It is first constitutional amendment, section 6 referred to by Azad. In fact, you can also look at section 273, which has specifically said that the court will be presided by at least one judge, a single judge. So members of the jury cannot be referred to as judges. There is nowhere in our entire constitution that jurors are mentioned. So we cannot start it in that hurry and manner and think we can get results. Now, in jury trials, it may be limited by so many factors. First of all, like I said, it may be limited by the law itself. 2, limited by the prosecutorial discretion. 3, by judicial decision. And 4, as it is obtained even in the US by defense waiver. Now, because the defense, in some jurisdictions, the defense can decide. They have a say in whether they will be tried by a jury. The moment they decline, then you can't have a jury trial. In other words, there is no compulsion in jury trial in some jurisdictions. But from the way the presentation I'm seeing now, as if you send a bill to the National Assembly of States, and a law will be passed to say that corruption trials must be by jury. Whereas in the jurisdictions we are trying to emulate, there is the provision, there's a discretion of first the prosecution, 2, the court, and lastly, the defendant, as they are called now in this country. So it is a very, very lengthy process. For instance, The only exception would be with the promulgation of ACJLs in a lot of states and the ACJA, where the prosecution has always been manned by police in the lower courts. Now, if they decide which court the matter will be taken to, at least my friend Idris is aware of it. You could decide that this matter is going to Sharia court. And it's not even every Sharia court. I will decide that I will take it to one Sharia court judge that is my friend, so that I can deal with this guy. And then let's not forget that our laws make provisions for criminal direct complaints. And the criminal direct complaints do not also exclude even corruption issues. Because even the ACJA makes provision for that. So if I am the one that is deciding somebody has cheated and I want to do this, handle this issue myself, there are procedures I will follow to get it. Now, will it be affected by, is there a jury that will determine it on the facts? As it is, we know who determines those issues. So I think we should treat this thing with a lot of caution. As plausible as it appears, there are a lot of obstacles along the way. I know they say a journey of 1,000 miles starts with a step, but let's not start it with a mile. So that is my humble contribution to this discourse. Thank you very much.
Thank you very much, Leonard Silk. Your thoughts and your guest contributions to this topic are well received. May I now ask for some remarks on the paper delivered and the guest contributions made by our two guest contributors from the chairman of this webinar, Professor Sadiq Issa Rada. Sir, I would love to hear your comments on this paper and the guest contributions, if you have any, sir. Prof.
Hello, can you hear me now?
Yes, sir, we can hear you loud and clear.
Thank you so very much. Well, since we began, I've been following the delivery of resources by all. Shakura, and I think at least we're making headway. We're making headway because some of us who are not lawyers are beginning to understand the reality. The reality being that even though we desire the jury system to help us in the administration of justice in Nigeria, we have a long way to go. But I believe it's a long way that is desirable, and it's a long way that we should struggle to get to. Now, the 2 or 3 comments I have regarding Abila's presentation is this idea that corruption, has pestered in, and the judiciary has not been able to solve the problem. I concur with him. Now, the point he has emphasized, which I want to re-echo, is that let us as Nigerians not concentrate on law enforcement. And by law enforcement, I mean the police, ICPC, EFCC, NFIU, Code of Conduct Bureau, Custom, Immigration, etc., etc. Because if you have parents not performing their duties, if parents assist their children to be criminal, if school teachers assist children to be criminal, if religious leaders turn a blind eye when people are becoming criminal, then we are making the job of all law enforcement agencies extremely difficult. You cannot just be supporting your child to be Yahoo boy, only to accuse the government of allowing crime to fester. It's first, let's complain of parenthood, teachers, religious leaders, community leaders. This is the soft power we need to deploy in Nigeria, which will make the job of law enforcement very easy. That is very important point made by Habila, and I concur with him totally. The presentation by Professor Bolaji Oasona was very clear that we want to get to the point of adopting jury system, but we have quite a number of things to do. And I think we have to work with the organizers of this program to see that all these things are done. They cannot do it alone. So the group organizing this meeting should be supported in whatever way we can so that they can actualize the objective. The last speaker was saying that there is no guarantee. If you have a jury, they cannot be compromised. But look at the possibility, what is the chance? What is the probability of compromising a judge and compromising, a group of jurors? The possibility of compromising a judge is extremely higher. Maybe a judge of integrity, if you have a system that is bad, can be made very bad. But if you have a group of jurors that have integrity, it's going to be extremely difficult to compromise all of them, because it's going to be a coalition of conscience. Remember that before they are selected, there are certain conditions they must meet. There must be people of integrity, there must be people of honor, they must have basic knowledge of, they must have some knowledge, they must have some education. So they are not going to be an ignorant bunch. They are not going to be just ordinary people. They should be people that can be trusted. So if you have a group of, let's say, 11 jurors deciding a case, I think they will be less likely to get compromised than a single judge, no matter no matter the integrity of such a judge. So give and take, we are doing well during this meeting. We are seeing the challenges confronting us, but we are seeing, the pathway to having a system that is going to help us. But more importantly, we are now coming to understand that fighting corruption does not lie with any single individual like the president or the vice president. It does not lie with the governor. It does not lie with the National Assembly. It does not lie with the judiciary alone. Neither does it lie with the ICPC, EFCC, Code of Conduct Bureau, NFI, or any security agency like the police. Fighting corruption requires us to begin from the beginning. Let us have decent homes. I will give you a last example. We had a meeting in Adamawa State. The chairman of ICPC told us that there is a mother who is supporting her child committing Yahoo in Malaysia. He has been able to steal as much as over 400 million, and the money was being sent into her account. And she's a school teacher. So NFIU was able to trace it, flag it up, and she got arrested. She said her child is in Malaysia and is doing Yahoo. So if you have a mother who supports her child to commit crime, then how then do you, yes, you can blame the government, but you should blame the mother as well. So parents should be parents, teachers should be teachers, religious leaders should be religious leaders. If you have three of these vital instruments on our life performing their duties very well, the job of other law enforcement agencies will be made very easy. Thank you very much for this opportunity, and let's on, work in progress, and we will succeed. Thank you.
Thank you very much, Prof, for that parental guidance. We'll now move on straight up, and The next item on the agenda are remarks from the Kadunan State branches of the Nigerian Bar Association chairman. Previously, we had, yes, he's back. Mr. Abdullah Yahya, Senior Advocate of Nigeria, Chairman, Nigerian Bar Association, Barnara branch. Your thoughts, sir?
Okay.
We seem to be having some problems with Mr. Abdullah Yahya's SAN's network. Lenny Silk, are you still there, sir? While we're waiting for Mr. Abdullah Yahya to come back online, I can see my friend and brother, Mr. Maxwell Kyong, the Secretary of the Nigerian Bar Association, Kaduna branch. Your thoughts are on this topic. Thank you. Mr. Maxwell Kyong.
Good afternoon. I hope you can hear me.
Yes, we can hear you loud and clear.
Okay. My thoughts in respect of this issue of a jury system and whether it is actually workable. Truly, I share a view that we already have a problem with the system that we are running. And indeed, we want to see some change in the positive direction. But I doubt, and I'm saying this in respect of my own personal view, I doubt that change in a positive direction would imply change by way of introducing a jury system. Now, I have a problem with the system as it stands today. In actual fact, we have problem in terms of delay. We have problems in terms sometimes of suggestions that are made of judges being compromised and all of that. These are real problems that are attendant with the system. But I do not think that, shifting to a jury system will correct these problems. I'll give you an example. Take the issue of cost, for example. My thought is that it is going to be much more expensive to manage a jury system. And let me give you a practical point in respect of this matter. I know as a fact that within the Kaduna judiciary today, even the issue of producing files is a problem to distribute to the courts so that there are files for use in the courts. Now, if we have a jury system, you have 11 jurors sitting in maybe 2 or 3 courts that are going to manage these corruption cases. Who produce the files and give them? How will they come to court? We already have problems with cases that we are doing where sometimes you find that a judge is unable to sit, probably because he's bereaved and all that. I was supposed to be before a judge yesterday. He couldn't sit. He was bereaved. He had to go for a burial. Now, if we have a jury system and we have 11 people sitting on the jury, what is the guarantee that you would have these persons coming to sit through a matter until it is determined? These are real life problems that we are going to face with this jury system thing. And then, of course, the last speaker talked about the issue of getting people of integrity and all that to sit on the jury. We have that would actually do some sort of background check and be sure that the persons who are going to sit, as jurors in these matters must be persons of integrity. The judges who are sitting already, the basis upon which a lot of them get to the bench is that they are men of integrity. That is actually how they get there. But they get there and we still find some of them being compromised. So how, for me, I think even though the suggestion has been made that, well, it's easier to pollute one person than to pollute 11. I do not agree, because I believe that, of course, it depends on where you are going to pull these people from. Are we going to insist that they must have some kind of income? We're going to be sure of how much they are earning, because while it may be actually be possible to probably corrupt a judge by way of offering him 10, 15, 20 million to compromise a matter, there are persons, no matter how you think, there are persons of integrity that you can compromise with less. So I think, for me, I think that what we need really to do is to look at the system as it is today and attempt to correct it using some practical steps in terms of checking the judges and how the system works now. I believe that a jury system is going to be a lot more expensive, a lot more cumbersome to manage, and the thought or suggestion that it would solve the problem of corruption, honestly, I do not think, or I do not subscribe to that view. I think that the problem of corruption really is not so easily solved by suggesting that the more people who sit on a jury to determine a matter, makes it, because of the fact that there are so much more, it will be difficult to reach out to all of them. It is possible. We have seen, even in the American system, where this jury thing has worked for a while, that these persons can actually be compromised. And besides that, the truth of the matter is that people come into these juries sometimes with preconceived notions, sometimes with preconceived ideas. How do we check these things? With a judge, he has a training that allows him, at least to some extent, to be able to filter his thoughts and look at the law, as it were. We are now going to pick people who have, I am not saying that because people don't have, these persons probably will not have a background in law and all of that, they may not be able to manage the questions of facts that will be thrown in their direction. And of course, yes, a judge will be there to give some level of direction. But I think that it would, honestly, considering the level of education and all of that in Nigeria, and all of the issues that are attendant with that, I think that it would probably make the system a little more complicated, and we may not ultimately get the results that we are seeking. Probably the jury system may work in some very future, in some very far, future and all of that. But for today, I do not think that it is the solution to the problems that we have in terms of corruption and management of corruption cases in Nigeria. Thank you very much.
Thank you, Maxwell Pyong. As usual, you have brought your ideas and stated them very clearly and lucidly. Dr. Isa Onoja, we see your hand, and we'll soon get back to you for your additional comments. I can see that the chairman of Barnawa branch, Abdullah Yahya, Senior Advocate of Nigeria, is back online. Can we try him one more time? I also saw the chairman of Kaduna branch, MT Mohammed. Oh, it's not here again, but he's also online. So Leonard Silksa, if we could try, maybe the network has improved, and let's see whether we can get your own thoughts and perspective on this topic.
Hello, Idris, can you hear me?
Yes, sir. We can hear you loud and clear, sir. Thank you.
Oh.
So you can go ahead, sir.
All right, I think I'll go over and then quickly run through it. All right. To a large extent, Maxwell has captured some part of my thought, but I want us to understand, just like Maxwell said, what is our problem today? Our problem is that we find that some judges, as Maxwell said, the basis of the appointment of a judge is not just the fact that he has knowledge, no, but that he has integrity. Now, if we appreciate that
Unfortunately, we seem to have lost the nether silk again. I think it's even totally offline now. Dr. Isa Onoja, please, you were raising up your hand. I don't know if you have any more reactions to the topic or a comment on what someone said. Dr. Isa Onoja, representative of Professor Bolaji Owasonoye.
Yes, good afternoon once more. I actually wanted to react to something Professor Rada said about the risks of witness tampering. I was once a litigator before I started working for government. There was an election petition that somebody was involved in, and to secure a particular witness, it took the witness, accommodated him in a hotel. They allow even close relations to have access to the witness. This was not the days of GSM, and he got a visitor that his mother had just passed. And now, how do you prevent a witness from going to see his family members when his mother has just passed? It turned out to be the opportunity for the other party to reach out to the witness, and a witness who knew that the aspirant had not resided in the constituency for the period of time to qualify him to contest. He was turned. So, and the evidence of the betrayal came out in cross-examination. So that's a pointer that if we start trial by jury without the infrastructure, the tools that we need, that we might be biting more than we chew. This is my own personal opinion. Earlier on, I spoke on behalf of my chairman, but I'm speaking now as a Nigerian, that perhaps we may have to think a little bit more deeply before we experiment with the trial by jury. That's my comment. Thank you.
I can also see the Leonard Silk's hand up. Mr. Elisha Kura, SAN, sir. You can now make your further comments.
Can you hear me, Idris? Can you hear me now?
Yes, sir, we can hear you loud and clear, sir.
Okay, thank you, thank you. jury trial, in jury trial, there must be unanimity among all the jurors that there should be a conviction. But in a situation where one of the jurors says, I don't agree, the entire thing collapses. So it only takes somebody to bribe or influence one juror to make the decision useless. That's how it works. So if we are talking of bribing one judge, influencing one judge, it's the same thing, because if we influence one juror, the entire 11 out of the 12, their decision is useless. So let's look at the way it operates. That what we are running away from by bribing one judge, we could get it by bribing one juror, and then the decision of the 11 jurors will not count. So that's the point I'm trying to stress. That so the issue of corruption is still there. There is no way we can run away from it. The corruption thing will still be there, because if you have 12 people and then you bribe one person and he agrees to do your bidding, that's all. I've seen a situation in our experience as legal.
Okay, we seem to have lost the sick. The chair of the Jury Justice and Rectitude Advocacy Initiative, Mr. Dave Mubi. Sir, you have the floor. I can see your hand, so you can just go ahead and make your contribution, sir. Mr. Dave, sir. While we wait on Mr. Dave to come on, I can see that the NBA chairman of Kaduna branch, MT Mohammed, is back online. Can you share your thoughts on this, sir?
Hello.
Okay, we now have Mr. Dave back. Please, sir, go ahead, sir.
Yes, I think this is a brainstorming session, which is good. This is an opportunity for all of us to look at the pros and cons, the possible shortcomings of the jury system in the light of the peculiarity of our environment. And in such a situation, we should not condemn the jury system in its entirety. Though the system emanated from the United States and UK, just the way the democracy started from the West. If we have to be sincere, you will agree with me that the democracy we are practicing in Nigeria, so we say we are practicing federal system of government. It is not the same federal system of government that is operating in the United States that we are practicing. So we don't need to adopt their jury system hook, line, and sinker. We have to look at the peculiarity of our environment to promulgate the law governing or regulating the jury system to match our peculiar environment. Peradventure, at the end of the day, they may even have something to learn from us. It is not cast in iron that our own jury system must adopt the system in America word for word. We can make our own law in such a way that majority decision will carry the day. That is what operates in our appellate jurisdiction now. So majority decision can be brought in, because it will be dangerous for Nigeria to now say that once a juror have a different opinion, that will be the end of the matter. The accused is set free. These are shortcomings we need to take into cognizance in drafting our own law. And I would also like to humbly disagree on the issue of integrity of our people. We were not like this in the days in the First Republic. Things were not as bad as this, even in 1979. So, since we were not created like this, we didn't start like this, there's hope for our country. Let's not write off this nation by any means. So, we should focus on a lot of things. And then we should not really condemn the judiciary wholesale. There are still personnel in the judiciary that have integrity, that can withstand pressure, political pressure, or any other form of pressure. What we need is to look at those failings, those shortcomings in considering introduction of jury system, so as to take care of those things in our environment. So I wouldn't want to subscribe to the view that we can bribe this. It's possible. It's what obtains. It's a reality that we have to face. But the law should be presented in such a way as to take care of the shortcomings that we are perceived ab initio now, rather than say, well, we should throw away the baby with the bath water. We don't need to follow word for word. Our constitution is purportedly fashioned after American Constitution. American Constitution, I don't think it's up to 10 pages. And we have about 300 pages of Nigerian Constitution. Is it working? The answer is no. Their own 10 pages are working. So we know our problem. We know the solution. So let us just experiment. We started with CPA and CPC. Then enters administration of criminal justice law, administration of criminal justice law in Lagos State. It was adopted at the federal level in 2015, and Lagos has since proceeded to amend its own. And even this year, the Lagos version of criminal justice administration law has been amended to prohibit police from calling media to display, to parade suspects. So that means law should be progressive. For now, before the promulgation, before the enactment, we know these shortcomings, we can take care of them. And we should believe the best for our country. Nigeria is not made up of corrupt people, but the situation, the type of government we have in place has forced some people into corrupt act. Our traditional system does not tolerate corruption. Otherwise, Nigeria will not even survive to the time that the colonial government came. We would have consumed ourselves. So let's not throw it away. I will suggest that the suggestions that have been proffered today, the organization will go into recession. I mean, we go back to the drawing table and look at it and how it can be taken care of in the draft form of enactment that we have now. And by the time it's going to be passed through the legislative houses, there are people too with creativity in the legislative assemblies that will bring in a lot of innovations which will be accepted. What we have now is just a proposal from us, our humble proposal. And the essence, we've learned enough from today's proceedings, which we can build upon. And we all just therefore that these solutions, these suggestions should not be taken lightly. Rather, we should go back to drawing table to reflect the peculiarity of our environment in the draft that we have. Thank you.
Thank you very much, sir, for your kind thoughts. That was almost like your closing remarks, but we'll still come back to you. But we'll take a few more contributions before we bring this to a close. The chairman, Nigerian Bar Association, Banara branch, Mr. Abdullah Yahya, AN, your hand is up, and we hope we can get you very well now. So,
yes, I sincerely hope, I hope that the network will permit you to get my contributions. Now, I'll just quickly run through them. Now, Mr. Ajitumobi has said something. Well, if we look at the introduction of the jury system as another way to enhance the administration of criminal justice, then probably we could think of how to improve on the system. But if we're thinking that introducing a jury system will curb the problems that we presently have, like Maxwell said, our problems are going to be multitudes, because there are situations in which you have a jury trial. The essence is for the jury to act based only on the evidence they hear in court. And therefore, there are times when you need to sequestrate the jury. Imagine a trial, a criminal trial of a corruption case which goes on for 4 to 6 years. If you take the trial of whether it was Darie or John Linyame, or you take the trial even of Kalu, the former governor of Abia, those trials took a number of years. So how would you have sequestrated a jury in such a period? And where do you even sequestrate them that they will not be influenced by public perception of what is happening? Now, the other thing is, I think there's a need to understand what happened because people want to make reference to the John Yusuf trial as an example of what would ordinarily happen when the present system is perverted. Now, the trial of John Yusuf was a trial conducted before the FCT High Court by the Economic and Financial Crimes Commission. Now, there was a plea bargain. It was agreed between the prosecution and the defense that the man would plead guilty to a particular charge and he would be convicted of that and the sentence that was supposed to be imposed. In fact, the judge gave to the defendant a higher sentence than what was agreed to by the prosecution. But the narrative that came out was as if the judge had been compromised and he gave the accused person a slap on the wrist. First, we all know that trials take place, the prosecution drafts a charge. It is that charge that is brought to court that the accused person stands trial on. So if the prosecution decides to charge a man who it is alleged has embezzled 133 billion for an offense which carries a penalty of 2 years imprisonment, is the judge now supposed to change the charge and say, oh no, go away. You must go back and charge him for an offense that carries 100 years imprisonment? We are aware that the system has flaws. The entire members of the panel who have spoken have conceded to the fact that indeed Nigeria has many judges of great integrity. The few bad eggs who pervert this system is the solution to the problem, throwing away the good and the bad. No, the solution is in ensuring that the system works such that when a judge is corrupt, he's disciplined. He's not just sent away on retirement and then he gets to receive his salary while he's in retirement as a reward for having been indolent or having been corrupt. No, he gets to be prosecuted, he gets to be tried, and an example is made of what happens to a corrupt judge. So my humble submission is, let's not throw what we have today. Even in America, the way the system works, there are times when the jury system is corrupted. So we can think of, as Mr. Jetumobi said, we can think of a system where the guilt of an accused person by a jury system is not based on an absolute consensus by all the members of the jury. But then we must not throw away what we have, because if we know what the problems are today with the system, then it means that we can improve it. But it also means that we can bring in some other systems that will help to enhance the administration of criminal justice. Those are my thoughts on this issue. Thank you very much. And I commend the organizers, and I hope that they will take all of the suggestions as a way of improving what will eventually come out. Thank you very much.
Thank you very much, Lenny Silk. We are very grateful to the network that we finally got to hear you.
Thank you very much.
Still, before we get back to the keynote speaker, Dr. Abila, for this general roundup and based on all the suggestions, I can see a couple of people that have been here with us right from the beginning and are still with us here. Babalawal Aliu, Federal Chartered Institute of Arbitrators, was here. I don't know if he's still here. Maybe we could get his own thoughts. Okay, he's no longer here. MT Mohammed too was here. Okay, he's back online. MT Mohammed, sir, the chairman, Nigerian Bar Association, Kaduna branch. Please, sir, if you could just unmute yourself and let us hear you. Your thoughts on this topic. Yes, sir. Mr. MT Mohammed, I can see your hand is raised. I've also said you could make your contributions, sir. Yes, sir, please go ahead. Except if you're having network issues, but you're unmuted and your video is playing, you can make your contributions. We can't hear you right now. We'll try and see whether we can get Mr. MT Mohammed to come back later. But meanwhile, can we go back to the presenter of the well-researched and well-delivered paper, Dr. Abila Hazard, for his closing remarks? So several suggestions and several comments have been made. So we want to get your reactions based on the paper you presented to some of these comments. Some have been in favor. You were not. You were particularly in favor of returning to the jury trial. Two guest contributors and some of the comments we have received have said, no, it won't work in our situation. What are your comments and your reactions to this? So, thank you.
Well, I want to thank you very much. I want to thank all the contributors for their perspectives. I want to thank my senior brother, Kadunan Silk, Shakura, and all those who have made their views. Well, like I did say in the presentation, the jury system is not a perfect system, by no means. But what we are advocating in my own, from my own perspective, is that we have seen how the current system works. And we have seen the shortcomings of the system as it is. Why not seek alternative? Why not chart a new course to see if it would be better than what we have? Nobody is saying that we should adopt the jury system as in America, hook, line, and sinker. No. But I should think that we should adapt the system to suit our peculiarities and our present situation in the country. So we should not look at the deficiencies of the system as practiced in America and UK and then speak against it in Nigeria. No, that is how laws evolve. That is how policies or systems evolve. You suit them, you adapt them to suit your peculiarities. And I think that Nigeria has its own peculiarities in many ways. And we can look at the system as it operates in other climes, and then look, how do we adjust them to serve our purpose? Now, the learners raised the question of unanimity of decision or verdict, that there must be unanimity, and that this is a drawback. One juror could be influenced, and this will affect the entire proceedings. But I would say that even in New South Wales and Australia and some other jurisdictions, this issue has been debated, whether there should be reform to change the current situation or the current status from unanimous verdict to majority verdict. So various countries are toying with how they can sort of reform the jury system to suit their purposes. In Nigeria, we can debate this issue. It's not to say we take everything that we find in America and then dump it on Nigeria. No, but let's start the process. And one of the contributors also said, in view of the challenges, the many challenges, that we cannot practice the jury system. No, I disagree completely, in the sense that the journey, somebody said, the journey of 1,000 miles begins with a step. And I did say in the presentation that even in America, it took a long time until the 6th Amendment. There is no problem with the push for the adoption of the jury system to begin now. Nobody is saying that today, if we agree on the jury system should start today or tomorrow. No, this can be a 10-year project. If it is infrastructure within the period that this where it will be implemented, certain infrastructure can be developed to sustain the jury practice. So I appreciate all the comments, but I still want to emphasize that in the case of corruption, I think that involving the people in the process will go a long way in ameliorating the problem of corruption in Nigeria. When the people have a role to play, they accept the process, and trust is reposed in the process. And like I did say, one of the problems we are having is that people don't have confidence in the judicial system as it is. Many Nigerians don't have confidence in the judicial system. It's not to say that all our judges are corrupt. I have stated it here earlier on, that we have fantastic judges, among the best in the world, very good judges in Nigeria. But there are equally those who are allowed themselves to be compromised. And this is one of the things that is affecting corruption trials in Nigeria. Probably some of these corruption trials find their way into the wrong hands, But the honest truth, or the fact on the ground, is that a lot needs to be done to sanitize the system. And I should think that we should give the jury system a trial. After all, it existed in the country before 1976. Why the military discarded it is beyond any explanation. Probably the military didn't want civilian participation, but they discarded without any plausible reason. So why don't we go back to it? Look at area. Go back to pre-1976 and look at areas where there were problems in the jury system and try to correct them and chart a new course, so that the fight against corruption in Nigeria can receive a better bite. I want to say thank you for the privilege. Thank you for the opportunity. Thank you.
Thank you very much, Dr. Abila. Dr. Grace Dafiel, I can see your hand up, so you'll be our last contributor for today before we go to take the Chief Judge's final remarks and the Chairman's closing remarks and the vote of thanks from the Jury, Justice and Rectitude Advocacy Initiative. Dr. Grace Dafiel, you have the floor.
Good afternoon, everybody. I pray to stand on the existing protocol. In addition to the last speaker, I think we should give the jury system an opportunity. I'm looking at it from the angle of dispensation of justice. Looking at the issues and how cases drag in our courts. When we have that in place, it can expedite action in reducing some of this burden on the justice system we currently have. And just as the last speaker said, a journey of 1,000 miles starts with a step. We could start by building the consciousness of people. We could start by building the necessary infrastructure to ensure that when we hit the ground running, we will have everything. That is not to say that we are discarding what we have. And that is not to say that we will not try to bring about improvements in the current system that we have. So I feel that trying something new that will help us to expedite action in order not to delay justice and in order not to drag on cases, as we saw in so many politically instituted corruption cases. I feel that giving the jury an opportunity will go a very long way in redressing some of these issues that we are facing currently, and also helping us to, especially the masses, to know that we have alternative that we can rely on, and then rebuild our faith and trust in the judicial system. Thank you very much.
Thank you very much, Dr. Grace Dafiel, for being concise and straight to the point. Thank you. May I now call on the representative of the Chief Judge of Kaduna State, Honorable Justice Darius Kobo, for his final remarks.
Can you hear me?
Yes, sir, we can hear you, sir.
Thank you very much. On behalf of the Honorable, the Chief Judge of Kaduna State, Honorable Justice Mohammed Lawal Bello, in respect of whom I stand in, I want to express a profound gratitude to the organizers of this symposium for enabling us to have a very thought-provoking ideas on how we can restructure the administration of criminal justice in Kaduna State and in Nigeria at large. Well, we have heard a lot of contributions from the participants, both for and against, the pros and the cons for having the jury system. My closing remark here on behalf of the CJ is that the organizers should take all these contributions back and go back to the drawing board and see how we can work assiduously, collaborate together, and see how we can effectively bring in a system that will enhance administration of criminal justice in Nigeria. I must commend the organizers. It's a very well-deserved, well thought out symposium. And I'm sure if all hands are put on deck, all the bottlenecks are removed, and we have a system that is all encompassing, that is all acceptable to the people, it will help us to enhance the administration of criminal justice, both in the country, and the end result is that confidence will be reposed in the system, which is what we already have now. But we have some little issues because of this corruption. Corruption is already known to us. It's one of the basic problems we have. If the administration of criminal justice will be strengthened, and we feel that the jury system is going to help in any way, we must take into account the problems associated with the jury system, clear those problems, and make sure that once it is implemented, it will definitely come in to help in enhancing the administration of criminal justice. Thank you so very much on behalf of the Chief Judge of Kaduna State for bringing us into this symposium. And we hope that at the end of the day, the organizers will go back, take all these contributions together, and chart a way forward. And then we look forward for effective collaboration to see how we can make a reality what we are thinking of, whether to introduce the jury system or not to introduce it. And if we are going to introduce it, the bottleneck should be taken care of. The constitutional amendment, the other issues raised by the contributors should be attacked frontically, so that when we are going to have the jury system, it will definitely help to take care of the challenges that we have now. Thank you so much.
Thank you very much, Milord. As usual, we have brought in your thoughts very clearly and eloquently. We'll now go on to get the closing remarks of the chairman of this webinar, Professor Sadiq Isarada, the executive secretary of the Presidential Advocacy Committee Against Corruption. Sir, your closing thoughts, sir, Professor. Prof.
Well, thank you so very much. the master of ceremony. The chairman, the committee is called Presidential Advisory Committee Against Corruption, not advocacy.
Sorry,
advisory.
Advisory.
Thank you very much. Well, my closing comments is that it is time well spent. For some of us who are not lawyers, who are not judges, who are better informed regarding what is the jury system. To me, we can see that we have a long way to go, but we have started the journey. For me, we are not doing this for us to reap the benefits now and today. Rather, we are beginning a process that will somehow, someday, maybe help our society, help our country, help our children and grandchildren. So we should continue the discussion, believing that somehow it's going to give some fruits. But what is very evident is that it's not a simple journey, it's a marathon. We have a lot of issues to address. We have a lot of bottlenecks to untidy. We have a lot of housekeeping to do. So it's left for the organizers of this meeting to look at all the issues. For example, if you look at our society, you look at our people, and then you look at the jury system where you have 11 people who have to announce guilty unanimously. Look at our society today. Like senior advocate Kura said, it's very easy to compromise one person out of the 11, just now as it is easy to compromise a single judge. So you see that what we have versus what we are likely to have using the jury system may end up being here nor there, neither here nor there. So I feel we should continue the discussion, but we should not be oblivious of the fact that this is our country, this is our society, this is our people, this is our character, this is our attitude. We should not have a system simply for the sake of having it, but we should have a system that will add value. Then finally, I'm calling on the organizers to look at, since this is recorded, they should transcribe the entire program and send copies to all the participants. Also, they should send the speeches of all the people that have delivered official speeches, because I'm sure they have papers presented. So we should have soft copies so that some of us can read. And since we're in the university system, at least we can educate our our students regarding the jury system. On this note, I wish us well, and I wish to hope and pray that we'll have a better system for our country so that corruption will be brought to the barest level. Thank you very much.
Thank you very much, Prof. Can I now call on Mr. Ogene Eshomomo to give the vote of thanks of the Jury, Justice and Rectitude Advocacy Initiative, the organizers of this webinar. As you would agree with me, it has been a very educating and enlightening webinar, and we pray that this would be the first of many such webinars that they will be organizing on the various initiatives that they are supporting. We'd like to thank everybody that has stayed here from the beginning to the end. Mr. Eshomomo, sir.
Thank you very much, my able moderator. On behalf of the Jury, Justice and Rectitude Advocacy Initiative, first of all, I want to express my sincere gratitude to Almighty God and to every one of us present here for making this time a really well-spent moment. Before I make my wrap up, I want to encourage us, there's a questionnaire. We always deploy that at the end of our events to be able to take a proper sample of, the perspectives, the opinions and thoughts of participants. So I'd like us to, at the end, just check up on the poll and then fill in. It's just a few questions. The chairman of today's event, the Executive Secretary of the Presidential Advisory Committee Against Corruption, Professor Sadiq Isarada, you've been very supportive. The PACAC has also been very supportive. We appreciate your presence here today, staying with us from the beginning to the end. And we apologize for the few minutes we spent delayed. I should also add this, that yes, we are going to look at the all angles that have been said. And indeed, we are capable of putting forward our best thoughts. Our legislative draft team is fully abreast of their task. And there's a lot of constitutional review processes that we're looking at, probably in section 36, or in section 273, the constitution of the judge, the high courts, or the judicial, as it were. There are several angles for which we can come around this, but yeah, I should also say that in the quest for a better Nigeria, we are trying to pick our fights and say that it has to be a collective responsibility. Like the keynote speaker rightly said, the responsibility of making a better society is for evidence, for facts to be on trial, not the law being on trial. Because the quest for the truth must be our choice of what we decide, whatever verdict comes about. The society is supposed to be seen as the beneficiary or the victim of criminal incidents or corruption cases, indeed. And so, yes, we are focused on what the Constitution says, what the law says. Indeed, we have put together a proposed draft bill. I'm sure Daniel Silk, the guest contributor, Mr. Elijah Chakura, has looked at it. Same also as the Kadunan State Judiciary, led by his Lordship, Honorable Justice Mohammed Bello. And, we know that, yes, there are areas that we can, look at. We are working with the legislative arms, the National Assembly, we're working with them. The state assemblies, we are also in touch with them, because we understand that the processes of reviewing the Constitution to introduce such, it's quite a marathon, as the Executive Secretary of PACAC, the chairman of today's webinar, said. It's quite an Herculean task to go through those processes. But yes, again, it took until the 6th Amendment, as it was emphasized, before it was put in as a clear right. But the practice had begun. And in fact, there are some video, going around, and I learned quite well that, in fact, the jury system also emanated from Islamic law. So we understand that a lot of these things predates Constitution, a peculiar way of governance. It only just guides how the society should function vis-a-vis the crimes that are committed and how adjudication should really take place. So whilst we are pushing for the restructuring of the judiciary, and I'm glad that Honorable Justice Darius has, given us is an open-minded and giving us the thoughts of both himself and the judiciary, Kadunan State Judiciary, and indeed that of the Honorable Chief Judge, who has been open-minded. And indeed, I always want to call him the chief host of today's event, but for his unavoidable absence. The perspectives are obvious, but we should not take away the area where when trials come forward, when criminal cases are before the judiciary or the courts, we always allow technicalities to take control. We want to practice law, but the people are there. And so we must be conscious of this. And one issue that I believe has always elongated court cases is the issues of injunctions. You know, they always move motions to, you know, on technical issues, on the law. Whereas if cases are tried basically, more importantly, on the evidence, I'm sure that the time it takes for cases to be tried will be a lot shorter. And that will mean reducing the cost of justice, precisely because if you focus basically on evidence and you can run the case in what, 2 weeks, 3 weeks, 4 weeks, unlike when the law, the technical issues are going to be used and, you know, complicit counsels, or where there are also, you know, members of the bench who are in bed with the corrupt, then you have the years it will take. And of course, we know the implication of time for justice, and also the implication on the economy, because the repatriation of such funds, the funds have already gone by the time the cases are concluded. Maybe a piecemeal is what that will be gotten at the end if such funds are eventually even found, or if the person is found guilty. But if we are to focus on the facts, the evidence, the truth, we would have saved ourselves a lot of time, in which case we would have saved ourselves a lot of money. So we're looking at the draft bill. The proposed draft bill has gone forward. There are several innovations that have been introduced. In fact, witness examination can even be done virtually. Of course, our system now has adopted virtual sittings to an extent. So we know that witness testimonies, cross-examinations can also be taken virtually too. And it has been introduced into the proposed draft bill. There are several other innovations, including the majority, you know, the judgment, the verdicts based on majority decision, not on unanimous. In fact, the process that we are putting forward has also highlighted the need for public participation so as to minimize the participation of persons with questionable characters, rather, permits me. Persons with questionable characters can easily be screened by the public. We are all in the quest for justice, and nobody has more rights than the other to claim injury where corruption has taken place than the people, especially the masses. So the issues are a lot when we are considering what is at stake and why we are pushing forward the jury system. And there are areas where we may be able to accommodate it whilst the constitutional amendment process may be carried on side by side. But in all, both sides of the argument have been put forward, and we really, really appreciate it. Our keynote speaker, who represented the Director General of the Nigerian Institute of Advanced Legal Studies, Professor Mohammed Tawfiq Lada. Dr. Abila Azad, you did a fantastic presentation, and I must say, thank you, a big thank you. We've been in touch with NIAS for quite some time, back and forth, trying to look at issues where the Constitution intervenes, where it may give us allowance, maybe there's some lacuna we can explore, or how it may even go forward, getting the buy-in of the bench, of the bar. And we really appreciate you. Please extend our gratitude to Professor Lada. Your Lordship, Honorable Darius, we appreciate your presence today on behalf of the Honorable Chief Judge. Thank you for making out the time to be with us today as well. And we assure you that all the submissions made will be reconsidered, will be reviewed. And of course, we have already put forward the proposed draft bill, Kadunan State Jury Service draft bill before your Lordships. And well, we would come again and look at the areas that there are concerns, and so that we can go forward from there. And indeed, we are also looking forward to working with you on the stakeholders review of the draft bill, whilst we are working on the constitutional amendment angle with the National Assembly, We are in touch with the Nigerian Senate and the House of Rep. So we are taking everything at its time. And thank goodness that the chairman of today's event is the executive secretary of PACAC. So we know that with NIAS and PACAC, we can make some progress in those areas in terms of advocacy and getting the needed support from those institutions. We appreciate you very much. The chairman of the ICPC, Independent Corrupt Practices and Other Related Offenses Commission, Professor Bolaji Obasanjoye, SAN. We also want to thank him, even though he's unavoidably absent. He says he's out of the country, and we know he's doing a fantastic job. We thank you, Dr. Esa Onoja, for your contributions. They have been well noted, and we would do our very best to address all the issues that have been raised so that we can move forward with the trial by jury system. The Kadunan State government, well, they may not have been very much present. They said they would be present, but we appreciate them because without them as well, we may not have been able to reach out to a lot of the bar, especially because their support was also crucial to us getting Kadunan State engaged. We thank Mr. Elisha Kura, SAN, Leonard Silk. We've engaged on these issues a couple of times, and we thank you for actually sitting in person to deliver your remarks, because it means a lot to us, because we have different sides of the argument. And, you know, in the course of nation building, we cannot all say that nobody knows it all, and 101 professors will still need to, you know, pick their best brains to be able to get the juice that will make the wine. So we thank you for your opinion and your perspective, and we really value it, and we would work really hard to make sure that we can get the support of all those we need, so that going forward, your contributions and support will help to boost the process. And of course, we are all pushing for enhancement of the criminal justice system. That's why we're looking to restructure it. We're not looking to throw away the ACJA. ACJA took quite a while, and ACJA is doing fantastically well. And I believe that the jury system can also do as good as ACJA, can make the process even more better, much more than ACJA has done. It would enhance the process. A lot of concerns were raised at the inception of introduction of ACJA as a bill translated into a law in Lagos State Act, and then all the states adopted it, because they saw that the penal code and the criminal codes that we had were now beginning to be obsolete. So the society is dynamic, is evolving, and there were times when the 1% of cases, criminal cases that were tried before in the UK, as you cited, were much more. Why? Because when they adopted it, the need arose, and so they had to. But the system, the society has become enhanced, much better, and all of that. So it's the practice of trial by jury is somewhat now reclining, because the society has formed. Moral rectitude was there, and the situation of justice, administration of justice has improved significantly. So we thank you very much, Lannis, and we hope to engage you even more. The other bar chairman present, Mr. Abdullahi Leonard Silk, we thank you for your contributions, and we're looking to iron or address the issues that are therein with you, to be able to get a much robust process that can help us go through this marathon. Our other distinguished guests, we appreciate your time. We hope that we've learned a thing or two. We would endeavor to send you all the materials. The chairman of today's occasion has mandated that we do a transcribing. We will do our very best, and we would get them across to you as soon as possible. We appreciate the time spent, and it's really a pleasure to have had your thoughts expressed to us. We appreciate that very much. And indeed, we say a very big thank you, a very, very big thank you. Our moderator, we appreciate you, sir. Thank you very much. Even though it was quite a short notice, you've done an excellent job keeping things together. Thank you very much, sir. On that note, once again, I would say please kindly fill in the questionnaire, the poll, so that we can have a better opinion of some of the other issues that are there. The Jury Justice and Rectitude Advocacy Initiative, basically, we are a think tank, public policy, and our core areas are justice, unity, renaissance and rectitude, youth emancipation, and sustainability. We are pushing hard on justice, and we want sustainability for the process of justice. And we believe that this administration will not be able to solve the issue of corruption if all hands are not on deck. We need all hands on deck to fight the monster of corruption. And the platform we think best is jury system. On that note, once again, thank you very much.
Thank you, Mr. Ogene. And that brings us to the end of this webinar. Once again, on behalf of the Jury Justice and Rectitude Advocacy Initiative, we thank everyone that has contributed and all those that have stayed from the beginning to the end of this webinar. Thank you, everyone. Thank you. Goodbye.